The Constitutional Court yesterday ruled that labour brokers will no longer be dual employers after their clients have been hired by companies after 3 months. This changes the nature of temporary workers as well as the labour broking sector. For more on this, I'm joined by the CEO of BUSA, Tanya Cohen. Thanks so much for your time on SABC News, Tanya. Just talk to us about BUSA's reaction to that ruling yesterday.
So we think the judgment gives clarity, and that's exceptionally helpful. We think that what it does is that it means that labour brokers now can continue to operate. We know exactly where the liability lies, and we know that workers now can claim both against the client as well as against the labour broker. So it gives clarity in that regard.
The unions were very happy with the ruling yesterday, saying labour brokers are exploitative. Just speak to us about people who are also invested in our labour sector, the kind of relationship you have with those unions.
Yeah. So in terms of the unions, we have obviously been battling with this whole issue in terms of how do we secure a very fair labour market framework, make sure that there's both the flexibility to do business as well as the security and the protection that's necessary for workers. So we've been engaged in NEDLAC for a very long time on those deliberations, and I think we have a joint commitment to making sure that we fix those issues. We think that this case provides some clarity that's helpful, because what it does is that it allows the labour broker to operate legitimately, but it makes it very clear what the obligations are when there is that triangular employment relationship. But I think what you've got to recognise is that there's a really important role that is played by the labour broker in the South African work environment, because on a daily basis they're placing approximately 700,000 to 1 million workers into work. And they play a labour market facilitation intermediation role. So it's in all our interests to make sure that the employment that happens under the labour broker sector is lawful, that it's fair, but that it actually is stimulated to enable people to participate more effectively in the economy.
Can you talk to us, you spoke about a fair labour market. Another issue around labour that's been in the news is the minimum wage and the differing views that are coming out about. Speak to us about that, and also your engagement with NEDLAC generally, especially on the Job Summit as well.
Yeah. So we were engaged as the business representative in NEDLAC on those very long and extended deliberations that resulted in the National Minimum Wage Agreement. There were two very big agreements reached. National minimum wage was one of them. The Labour Relations Stability Agreements were the other part. And both those agreements have now found their way into Parliament. And we're waiting for parliamentary recess to end. And hopefully those pieces of legislation will come through Parliament and be brought into effect soon. We think that they both play really significant roles. The minimum wage sets a common platform across the economy in terms of what is a minimum hourly rate of pay, and we think that that's important because it sets a base. It is by no means a living wage, but it is a step in the right direction, and it means that people who are in employment are going to be remunerated at the minimum at a fair level. In terms of labour relations stability, there's a number of new provisions that are coming in that really give greater capacity to the unions, to employers, and greater guidance to engage in industrial relation disputes. It fundamentally, we think, changes the tone of labour relations to something that's far more constructive than what we've had, but it recognises both the right to strike and businesses' right to do business.
Let's stay with the minimum wage. It's quite an emotive issue for people. I know I was interviewing Musi Maimani this week, and he was saying that people should be able to opt out of the minimum wage, especially as workers, because in a country in South Africa, like South Africa rather, with about 26.7% unemployment, sometimes people just want access to jobs and they don't want to have to say, no, I'm only going to work if I get paid around 3.5 a month.
Well, it's a very fine line between at what level do you set a minimum wage that you don't mitigate, that you don't cause job loss, but that you also make sure that it's a fair minimum wage. And we know that there are some labour markets that operate on the basis that whatever the person's prepared to accept, then let that apply. But that's not how the South African labour market applies. And we think that what's the combination of the agreement that's been reached is that there is the minimum wage of 20 Rand an hour. There is the ability for businesses to apply for exemption. on the grounds of affordability. And we think that that's the mechanism that will be used to make sure that where businesses can't afford, that they can get a form of exemption. So that's a very important provision. But in addition to that, there's very clear agreement, and it's been written into the law, is that the National Minimum Wage Commission will monitor the impact, and adjustments can be made. So if we find that there's an employment impact, and no doubt there might be in the short term in particular, there's going to be some adjustment, well, then we can look at it again. But I think we've highlighted, certainly from a business perspective, the concern around particularly some of the labor-intensive sectors where there's low skills and low pay, is that we don't want to see job loss in those sectors. And smaller businesses, which really, really struggle with pay as a general rule.
Tanya Cohen, CEO of BUSA, thanks so much for your time on SABC News.